Good afternoon, everyone. On behalf of Caesar Stone, we're pleased to invite you guys to the next Education Center. This session is on a brave new world, the present, and potential future of mechanics liens. Presented by Greg Harwell. Greg's with Slates and Harwell LLP. Greg has over 25 years legal experience and is involved in almost every conceivable situation where the law and construction intersect. And he is an expert on mechanical lien laws, so please join me in welcoming Greg.
All right. Thank you. Well, I appreciate everybody being here, and if it gets too boring, we can wrap me up in Tyvek and throw me in the Acme brick display. But I want to talk today about mechanics liens, both historically and potentially in the future, because there's a big push from the subcontractor supplier lobby to change and completely revamp mechanics liens. And if it does come to pass, it would make a tremendous difference whether you're a owner, developer, builder, or subcontractor and supplier. So the first half, when I talk about mechanics liens generally, I'm going to talk about why are there such things as mechanics liens? What are they? How does that help collection and performance of payment from an owner or general contractor? How do you create them? What are the steps to make to create a mechanics lien? How would they impact members of the building industry, whether you're the claimant or the contractor or the owner? And if they're changing, how would they change? Now, I was looking back in preparation for this and noticed that it looks like I've been giving similar speeches for the past 20 years, which won't, if that won't make you rethink your career choice, I don't know what will. But what I've seen happen over the past 20 years is about every 2 legislative sessions, the property code changes, and they add more wrinkles and twists and turns to the existing mechanics lien statute. And it's become more complicated, more difficult to deal with, and that's one of the reasons why people have been trying for the past 3 sessions to enact changes to the mechanics lien statute. Now, what's the background, the public policy behind mechanics liens? It creates obligations that don't otherwise exist in the natural world. And by that I mean, you've got someone that has provided materials or labor or performed some work of value, and the person they contracted with is not paying them. Well, by the miracle of the legislature, that unpaid claimant can look to someone that they are completely aliens to for payment, an owner. And that owner may flow down that obligation to a general or prime contractor. So who else gets special treatment under the law? Those that are clinically insane can get out of their contracts. Those that are minor children can get out of the contracts, or subcontractors can get out. I jest a little bit, but this is a unique situation where subcontractors and suppliers can seek payment guarantees from somebody they have no relationship to, an owner of a project. Now, mechanics lien statutes have analogues to be found almost every state. I think 49 of the 50 states have some type of mechanics lien statutes. But an analog is found in federal law. If you work on a military base, a VA hospital, or something like that, there are procedures to make a claim against a bond that a federal prime contractor has to put up, and that's a federal Miller Act. If you work on a municipality, a university, a high school, a city hall, there's a government code provision, the Texas Government Code, that a bond must exist. If there's a private project that has a general contractor who puts up a bond, there are procedures to make a claim against that bond, deadlines to give notices, etc. Since 1847, there's been a constitutional lien in the Texas Constitution that says if someone hires you directly and you perform repairs or improvements to their property, you can file a constitutional lien against their property and foreclose on their property. And I'll talk about the limitations of that. And then finally, the major thing that I'm here about today is statutory mechanics liens, what they are and what they may become. So under the Texas mechanics lien statute and the constitutional lien statute, there are 2 general thoughts behind it. For a constitutional lien, It's very simple. It's literally a one-sentence provision in our Constitution that says anyone that provides repairs or installs an improvement to real property has a lien on that real property to secure payment. And it only helps the person that was hired by the owner. So it only applies to that first tier. Now, our statutory lien has essentially three policies behind it: notices, owner fault, and a limitations of remedy. And what does that mean? Well, that there's a series of notices under our statute that may impact the ability to file a lien. A notice of commencement starts the clock for people. That's discretionary, but it's a way for some owners and lenders to establish when construction commenced, and all liens have that same priority. Notice of retainage: if you're a subcontractor and you have a retainage agreement, you can notify an owner and preserve your right to recover retainage from your owner. Notice of special manufacturing, and I'll talk about that in a little bit more detail, but if you make something that's unique and only would fit or apply to a particular project, even if your order gets canceled in process, you can still lien the building for something you didn't supply if you've given a notice of manufacturing. Then there's two types of notices of late payments. That's the lion's share of mechanics lien notices that people talk about or think about. Notice to a general contractor that I haven't been paid, notice to an owner that I haven't been paid. And then finally, there's a notice of completion that an owner can send out that puts everyone on notice that they have to file their mechanics liens. Now, if that's the notice, the overly complicated notice world, owner fault means an owner is the master of his own destiny. An owner can make sure he does not have to pay more than once for his construction project. The way he can do that is if he receives a retainage notice or a late payment notice, if he sets aside money equal to the amount included in the notice, then he can prevent himself from being subject to having to pay twice. Pay his prime contractor once and pay the notice party once, the notice claimant once. Or if he establishes a 10% reserve of the value of his contract for 30 days from completion, he can have a safe harbor and not have to pay twice. These things are rarely utilized, and I'll talk about them in more detail. Notices typically to an owner typically do create some action on the owner's behalf. But yeah, at this point, it's high level. But the complication of all of these notices and all of this situation is what made subcontractors and suppliers for the past 3 sessions want to push for a change to the mechanics lien statute. But this is the theory. Notices, an owner fault, meaning he doesn't set aside money, and then the remedy is you can foreclose on that property if the owner doesn't pay you what he should have paid you. So, this thing I mentioned called a constitutional lien. Again, it's only valid to those people that are hired directly by a landowner, but it could be somebody that simply installs a pool, builds a house, remodels a house, repairs a house. If you repair someone's air conditioning, you can, as someone in direct contract with an owner, file a constitutional lien against their property. So again, repairs are new construction, anything that improves or remedies real property. If there's a bank ahead of you or if there is a tax lien ahead of you, it's still second in line. You don't get to jump up to the head of the line, but it is a lien against their home or commercial property for that matter. You don't have to file an affidavit, but if you don't and the property gets sold, you lose your lien. Doesn't mean the person that hired you doesn't still owe you for breach of contract, but you lose your lien. And you're still going to have to file a lawsuit. All a lien does, it's just a piece of paper. It's a piece of paper recorded in the real property records, and it only gives you a backstop, a way to collect once you prove to a court, I performed work and I'm owed money. So these things don't mean you can go out and repossess their house in the middle of the night like a GMAC can, but it does mean you got some security, especially if an owner ends up filing bankruptcy, or they want to try and refinance, or they want to try and sell the property. They're going to want to clear their title. So constitutional liens are rare. I rarely deal with them. A lot of times for me, they're my hamburger helper for someone that's missed their statutory deadlines. If they were hired directly by an owner, I can say, well, you're in luck. go ahead and file a constitutional lien, real short, couple of sentences, and that way you've planted a flag, and in theory, you're now a secured creditor from that owner. So, statutory mechanics liens, what are they, and how do we create them and enforce them? So the folks that can file a lien, there are a lot of folks that can. Design professionals, if you're an engineer, surveyor, architect, they can file liens. There are procedures that they have to jump through. Landscapers can file liens. Now they need to either be part of a permanent improvement or they need to have a contract with an owner. So if you put up hardscaping, it's lienable. Living materials has some additional obligations and requirements that exist. Your standard subcontractor, your standard supplier. Those that just supply labor. Right now I'm dealing with a lien that was filed on a bunch of houses from a staffing company. So their personnel only were trained electricians and plumbers, but they would work, they weren't license holders, but they were at least trained, and they were working on homes, and all they provided was their hourly labor, but they're entitled to file a mechanics lien for their labor. What can it cover? It can cover rental costs, it can cover power costs, it can cover obviously labor and materials and designs and living plantings and things like that for landscapers. What property does it attach? It attaches to the real property and everything on it. You may have only installed $10,000 worth of hardscape, but you have a lien that may apply to a $20 million piece of property and development on there. So it's not limited to the value of your improvement. It's a lien on the entirety of the land and everything that's on the land. And if it's 20 acres and you only worked on 400 feet, your lien, as long as it's not subdivided, the lien extends to the entire undivided tract of land. Now, how is it triggered? It is triggered by sending timely notices and timely filing an affidavit in the real property records. And I'll talk about those in greater detail, but that's the process sounds deceptively simple, being 2 steps. It's actually much more complicated than that. And those that frequently find themselves either hiring people that don't pay folks downstream may get to learn the hard way, kind of the details and timelines and charts and what have you, or those that do a lot of work and don't get paid may need to learn what are my deadlines and start creating a system to track, I performed work and I haven't been paid. Now, what is an owner's responsibility? An owner really has 2 responsibilities. If you open up the mail and you get a certified mail letter that says someone hasn't been paid, you better make sure that that person does get paid and you don't release money after getting that letter, or you just create potential double recovery. I've already paid a prime contractor and then I got to pay again because maybe that prime contractor promised that, oh, don't worry, I'll take care of this. Go ahead and release the draw. Well, if he doesn't take care of that, an owner that releases money after getting a letter can be liable to pay a second time. And then finally, at the end of a project, if you're sitting on 10% of the contract value for 30 days, and you then release it on the 31st day or later, that owner is completely safe from facing a future mechanics lien. And I'll talk about these in a little bit more detail. In the single-family world, retainage is an alien concept. In a commercial world, it happens on all projects. Now, it may be 10%, it may be 5%, it may be early release, it may be staged releases. In single family, obviously, it's a much more alien concept. Now, there's no harm in that, except owners do potentially face up to 110%, an additional 10% exposure, because in this world, not a lot of owners set that money aside. So, let me talk a little bit more granular, it's painful detail about what these notices say and when they go out. Now, if I specially fabricate materials, and that's mostly going to be stuff that's unique, that's custom size, custom performance, they can't just deliver it to another project. Someone that specially manufactures Someone that specially manufactures materials can send out a notice of award. I was awarded an HVAC contract. I'm going to be supplying this specific project, this specific material. if they're those that are really on their game, and I really haven't run into people that are on their game very much in this world, they can send out those notices when they're simply given a PO. They don't even have to complete their work. But if they give that special notice and their order is canceled before it's installed, these special fabricators can get this special status of, hey, I have a lien right, even though they never used my artwork, they never used my HVAC, they never used something because I can't reuse it. It's now just, it's not usable in its present form. So again, that's a weird specialty that an industry went out years ago and got their own little section of the mechanics lien statute. And I would dare say it's so rarely come across, it's hardly worth mentioning, but it's in the statute. There's something called a second month notice. This is a notice letter that goes out for people that don't contract with the prime, with the general contractor, with that first tier. These are people that are suppliers to subs or sub-subs, and they're required by the law to send the general contractor notice that they have an outstanding AR, a 60-day AR. That's essentially what this is. The statute says if you don't have a contract with the general, if you've done work during a month and you haven't been paid for it, you have to notify that general that, hey, I've got an outstanding receivable by the 15th day of the second month after I've supplied material or labor. So I did work in May, and I worked to a sub, or I'm a supplier to a sub. I did work in May. July 15 is my deadline just to tell the general, I'm not telling the owner yet, I'm just telling the general I haven't been paid. Now, if your payment terms are net 30 or net 45, and you're a supplier to a sub, you're almost never sending this notice, and you don't know that all the lien deadlines have expired. And on behalf of builders and remodelers, when I represent them, or owners if they come to me in the residential world, and commercial world for that matter, this is the biggest thing that wipes liens off. It's even more draconian than the third month notice. So suppliers to subs or subs to subs who don't send out a notice when something is essentially 45 days past due, May, June, July 15th. So if they did perform in June, let's say they invoice June 30th, their payment is due July 30th. They will have missed their deadline to notify a general contractor. What's this third month notice? That's to notify an owner. Hey, and this applies whether you have a contract with the general or you don't. Everybody, except a general contractor, has to notify an owner. So this might be considered a general contractor's notice. This is an owner's notice. So this is, I've supplied material, I've performed work. It's now 3 months since I've performed work without getting paid. I've got to notify the owner, and the owner now has to hold funds for my benefit. So the technical statute says the 15th day of the third month after materials were provided or labor was performed for which payment has not been received, you must send a notice to an owner, certified mail, advising him of the debt and warning that if he doesn't set aside money, you can file a lien. So going back to my hypothetical, it's the month of May. I've done a whole bunch of hardscape work during the month of May. June, July, August 15th. Next Tuesday is the deadline for anybody that worked in May to notify an owner that they have not been paid for their May work. Then the third thing is, the final thing, again, mostly a commercial relationship, but if you have a contractual retainage agreement, there's 10% or 5% of my contract that's being withheld as a subcontractor. You can't wait till you finish. You don't have to bug an owner during the months that you're working, but you do have to eventually tell the owner within 30 days of when you finish, hey, just by the way, I've finished all my hardscape, I've finished all my electrical work, I've finished all my roofing work, and I've got another 5,000, 10%. You have to describe for them what your retainage arrangement is. That puts that owner on notice that you have the potential for claiming against that owner for retainage. Now, if I'm a prime contractor, if I was hired by the owner, whether it's a commercial, residential, development, any construction project when I'm hired by the owner, I have no obligation to give a notice because the owner knows he hasn't been paying me. And I've probably been reminding him every 2 weeks anyway, but there's no requirement for prime contractors to notify an owner. Their only requirement is to file an affidavit. Everybody, so subs and suppliers have notice obligations. Everyone has a lien affidavit obligation. That obligation is, after that person finishes his last bit of work, he's got 4 months to file an affidavit saying, I have not been paid. Even my notice didn't make me paid. So I'm now recording a lien against your property and the real property records of whatever county the property is located in. But you got to do both. And in fact, if you're lower tier, you got to do 3 things. 2nd month notice, 3rd month notice, lien affidavit. Now, what happens if somebody sends a notice but they get current, but they fall behind again? Someone that performs over the course of several months can end up sending several notices if several unpaid invoices start dragging on and on. Now, you can add every open invoice in a notice letter that you want, but there may be multiple notices if performance takes place over multiple months, but there's only one affidavit that has to be filed. So on commercial projects, the deadline is basically the 15th day of the 4th month after the claimant finishes his little work. Not when the building is finished, but when the claimant's work is finished. Now, for residential projects that I'll talk about in just 4 slides, there's a deadline that's a little bit shorter. But here, the second step of perfecting a lien, or having a mechanics lien, notices, lien affidavits, and then if you're going to try and recover your retainage, you can wait till the end of the project. If you've sent this notice, you can wait to the end of the project to file an affidavit that just ties back to that notice. Now, is this very complicated? Absolutely. Do I get confused every day? Does anybody want to talk with me specifically? Obviously, drop a business card by at the end, because people need to live this, go over with it more than just 25 minutes worth to figure these things out. So this is a relatively high and fast-paced explanation, and I can't. The handout that I give to clients is 3 pages plus a spreadsheet. So I appreciate that it is complicated. And in fact, one of the complications of this, again, is the reason why there's been efforts for the past several sessions to change. But at a high level, these are the elements to create a mechanics lien affidavit. Now let me talk about residential work. In '97, the legislature said, let's create a new and different obligation for residential projects. Let's shorten time periods, because Mr. and Mrs. Smith don't want liens filed against their house. Now, residential work is defined maybe differently than it would be defined in this trade hall. Residential work is limited to when an owner, the individual owners own the real estate when they sign that first contract for construction. So a spec house on a builder's lot is not residential. Oh, it's a one-family house or it's a duplex. It's not residential. The owner doesn't, the Mr. and Mrs. homeowner do not own the dirt when construction commences. The builder, developer, etc. owns that dirt. So that is not a residential. Pulte, building 60 houses in a subdivision, that is not residential work. Because that dirt was owned by a commercial venture, a production builder, a custom builder, a developer, that is not residential, even though a residence will go on it. Residential is limited to build me my dream house on my lot, or remodel my dream house on my lot, or repair my dream house on my lot. That is what the statute defines residential construction as. For those settings, that third month, that third month notice for subcontractors and suppliers now drops back a month to a 2nd month notice. Everyone has the same deadline. The 15th day of 2 months after you do work, Mr. and Mrs. Jones get that notice, because they know residential contracts are shorter in time, payments are faster. A 3-month notice period would likely come too late, so the deadlines are a month shorter for both sending notices out and filing affidavits. Suffice it to say, on a remodel and construction on a homeowner's lot, the deadlines are, the content are the same, the deadline is quicker, and hopefully lenders will know some of these obligations that will help everyone along, the builder and the homeowner along, to figure it out. Now, homesteads and residential can be similar, but they're not identical. Homesteads are defined at the time the contract is let. Almost no custom home on a vacant lot is a homestead. I know that sounds strange, but a homestead has to be a homestead when the contract is signed. So when you, remodeling projects, homestead all day long. New construction that will become my homestead, great, that'll be a homestead next time around. This time around, that's not a homestead. Yes, sir? Yeah, so great question. The question was, what if you're living in a house, you're hiring, and it is your homestead, does it rebuild on new? That property was certainly designated homestead with the tax district beforehand, and it'll maintain that status. The trick is, if you're a builder remodeler, are they living in it at the time they contract with you? Is it their vacation home? Not a homestead. Is it a second home? Not a homestead. Is it raw land and they're not living there, they're living somewhere else? Not a homestead. What does this mean? Not a whole lot of difference, but homesteads get an additional bit of protection, and again, it's determined at the inception of work. Was this residential? Was this a homestead? What do you have to do for homesteads? This can actually attach, a lien can attach to someone's house, and you can evict them from their homestead if these requirements are met. Husband and wife both sign. Husband and wife sign it before any work is performed. It is filed of record in the real property records. And in the notice letters that come out, there's some special warnings for consumers on homesteads. So in this setting, there are plenty of courts that will throw out a lien if only one spouse signed, or they can demonstrate that work commenced before that second spouse signed, or no one thought to file it in the real property records, or some of the warnings were not included on the lien affidavit or the warning letters. So homesteads get this special additional type of protection that regular residential and no commercials have. So let me talk briefly about advice to an owner. If you own a lot that you're going to do spec home or production home, you're a builder, custom or production, and you're going to build on there. It's not residential, so even though you're a builder as a profession, you're an owner for purposes of the mechanics lien statute. You have multiple prime contractors. You may think, hey, I'm building a custom home. I'm the builder. No, really, you're the owner, and you have 20 to 30 prime contracts. Your plumber, your electrician, your roofer, your framer, and all of these folks theoretically you have a retainage obligation of 10% of their contracts that at the end of the job, you hire a framer, the framer doesn't pay maybe McCoy's material for some of their materials. McCoy can send you a notice as the landowner, and you had a retainage obligation on your framer if you didn't buy your lumber directly from McCoy's, that McCoy may be able to get 10%. Even if you've paid your framer in full, you have a retainage obligation. And you don't get hauled off to jail. You just may face an extra 10% of exposure if you've paid that, quote, general contractor, the folks you have a contract with. And then you're going to be getting these notices, not from the folks you hire, you know about them, you know if they've been paid or not, but you may be getting notices from subs to them or suppliers to them. Now, what if you're building or remodeling on an individual's property, all of a sudden you are a contractor as opposed to an owner, and you may be you're clearly working on a residential project, but you may also be working on a homestead project, and if you are, for the benefit of your subs particularly, and yourself, you're going to want husband and wife signatures, you're going to want filed of record, you're going to want that documented and signed before you do any work. Notices then are going to come to the homeowner and are going to come to you. Now you also have lien rights vis-a-vis this owner. Now if it's a homestead and you haven't jumped through the hoops, all of a sudden your lien rights are no more. You still sue Mr. and Mrs. Smith, but you can't attach their house and you can't foreclose on their house. Yes? And I apologize, I can't. No, you do. You just have to trust that the prime general contractor has jumped through those hoops, that they've husband and wife signature, done before any work is performed and recorded, sometimes subcontractors have a difficulty getting that thing recorded because the homeowners don't want it recorded, and if the general's gone out of business, he's not going to record it. Beg your pardon? So the contract itself, the remodeling contract, and then anybody that is a sub or a supplier on Homestead Work needs to talk to a lawyer because their notice letters have to have this warning attached to the top. Missing that, and a judge may throw the lien out. Now, let me jump quickly through just the steps. So let's assume we figured out how to send notice letters, or you've received notice letters, and you've determined if they're valid or invalid. And then a lien affidavit has been filed. You still have to sue for a debt. You have to prove that work was performed, materials provided, payment wasn't made. You have to establish that all the hoops were jumped through. Then you get a judgment that says owner owes, even if the owner didn't hire me, there's somebody in between us, the owner owes the X thousand dollars, and if they don't pay within 30 days, the sheriff is ordered to sell their house. In any of these steps, eventually, if you can demonstrate all this stuff, that you're owed money, that you complied with all this stuff, 9 out of 10, you're going to get paid because no one's going to have their house sold for a $10,000 debt for countertops or something like that. But if the bank forecloses, they're paid first. And if the bank forecloses, it wipes everybody out. So let's walk through some hypotheticals and how they affect the residential construction industry. So I've actually had this question posed to me. I'm an HVAC subcontractor. I install my 3 exterior units. I'm not paid. I send my notice letter out. That's to the owner. That notice still doesn't get me paid. I come back up my truck on a Friday night, I cut off my condensing units, put them in the back of the truck and drive off. Now the question in this scenario is, how many years will he get for theft by doing that? Because title has passed. When he's bolted those to the ground, you cannot remove something you installed. You can file your mechanic's lien and proceed to try and collect. Now, what happens if the bank forecloses? Everyone but the bank loses. The bank wins, with a caveat. I'll go back to my HVAC contractor. If the HVAC contractor has done his due diligence, whether it's Homestead or not, if he's met all his requirements and the bank forecloses, he can file suit, shows he's owed, shows he's filed that debt, and there's something weird called the doctrine of removables that says if you can unplug and remove what you installed without damaging the structure, you can still do that. So there are a handful of folks, interior doors, cabinets, the exterior. You can't install the ductwork, but you could install the condensing units, the dishwasher. So there are certain categories of things that even if the bank forecloses, if you've met all your requirements, you can go out there, once you've got your judge approving it, you can go out there and remove things that are easily removable that will not damage the structure. You can't take off a roof, you can't take off doors, you can't take off windows, you can't take off framing, you can't remove paint, but there's a handful of folks that can remove what they installed. The hypotheticals, if you work on a homestead and you haven't gotten those dual signatures or it hasn't been recorded, the homeowner still owe that prime contractor the debt. But if the prime contractor went out of business and this hasn't happened, all of the subs have no remedy. All the suppliers have no remedy if these homestead requirements were not met. Or if you're the general and the homeowners just aren't paying you and they're judgment proof, if you haven't met and it's their homestead, even the general contractor, great, you get to sue and you get a judgment. If they have nothing of value but 2 cars in their house, you can't attach their 2 cars in their house on a homestead. Bankruptcy of the owner, you want to hopefully have a lien, unless it's a homestead. If the owner files bankruptcy, liens will at least get you paid more. Maybe not paid in full, but paid more if an owner files bankruptcy because you're now treated as a secured creditor. If they have an asset that can be sold, you'll get nickels on the dollar, not pennies on the dollar. And then finally, what's the thing that I see most? What I see most, because my clients in the residential business are mostly your production builders that are nationwide. The scenario I most often face is they get a call from a supplier of concrete, a supplier of drywall, or other supplier where that middle tier, so I am Nuco Home Company that sells 5,000 units a year, that's my client. The guys they've been hiring has been, over the course of time, losing money, and hoping to catch up and never does. So ultimately, he files bankruptcy. And 30 houses in a subdivision, he didn't pay for his concrete. He didn't pay for his plumbing fixtures. He didn't pay for his paint or drywall because they've been letting these things, keep extending him credit because he's slowly paying the oldest receivable last. When he finally goes belly up, the client gets notice from XYZ Materials that says, I've got 16 houses, 60 houses, something like that, and here are all the addresses that I supplied the concrete, the fixtures, the drywall to, and then we just sit down with an Excel spreadsheet and say, okay, when did you supply? Did you send me a notice? Because I'm an owner, in addition to being NewCo. And then it's very easy to try and just do the math because it's pretty simple. We kind of take at face value that they supplied concrete to all 36 houses, but just show me a delivery ticket and then show me where you did or didn't send notice. And we negotiate these things and we resolve them in 20 days because they just write checks on the 4 that were timely filed and they lose out on the 16 that were not timely filed. So now, let me talk a bit. So if this is the overly complicated mechanics lien statute that is difficult to follow by everybody, let me talk about, in the 8 minutes that I've got, the way that the subcontractors and suppliers have wanted to change the statute. From 1990 to 2011, since I started doing work on this stuff, there really wasn't much. The changes were all tweaks. Let's make the sausage even more inedible, because every 2 years something new would be added, some specialty change was made. However, in 2011 there was a lot of discussion about we need to revamp the whole thing. Some people like it. I like it. I think it has a public policy behind it, but a lot of people, especially subs and suppliers, did not. In 2013 they filed a stealth bill. Tab jumps up and several other people say you haven't vetted the bill through anybody, so that bill was never left committee. In 2015, the legislature appointed a task force to investigate that, and I'll talk about that in a second. And then this past year, a bill was filed in the House and the Senate, and it was opposed by a lot of people. Texas Association of Builders opposed it. It was a complete change to the system. It did not leave the House and Senate committees where it was in, but I think for the next multiple sessions, this particular bill is going to be pushed. So let's talk about it real briefly. I was part of the committee, the Lien committee from the legislature, and we spent some time looking at what can be done. Subcontractors had a lot of attendance, suppliers had some attendance, title companies had some attendance, general contractors had some attendance, and I was there kind of on behalf of the home building business talking about all these changes you want to make won't work. Lenders were not there, institutional owners were not there, but for 2 years we'd have monthly meetings where they talked about changing the statute. We talked about streamlining the current way it's done. I was an advocate for that in 2011 and 2013 and through this session, but it was just me, so that wasn't accepted. There was discussion about using a lien agent that would be a conduit for all notices and things like that. There was some discussion about, do you require everyone to bond a project like the federals do? Again, how can that work on residential? But ultimately, what the majority of folks came down to is what was filed, this idea of let's take out all of these notices, all of these obligations. All you have to do, this is how they sell it, all you have to do is send a notice of furnishing, notice that's saying, I am a supplier, I am a subcontractor, I am a laborer on the project, and that's all you have to do. And if you're not paid, and send it out at any time. And it's good for anything you did in the month before you send it and everything you send prospectively out. And then if you get to the end of a project and you're still not paid, you have 4 months to lien the project. So there's a single lien deadline. It's not independent deadlines for everybody, no notices, and it puts the owner's obligation, the obligation falls to the owner to check every month to see I got in 7 letters on my project, 11 letters on my project. If I'm building, the State Farm headquarters, I got in 68 notices on my project. Every month that owner would have to check, did all 68 of you get paid this month? Because you don't have to tell me, I have to go find it out from you. So This statute basically says there's a single notice, very generic, couple of sentences. I am, fill in the blank. I'm supplying, fill in the blank. No dollars amounts, no dates, just my name, I am supplying. Here's my address for contact, and that's it. That's all they have to do. Now, it's great for if you're a sub or supplier. It's a pretty simple notice, but it then puts the burden on the owner. Now, the owner is supposed to file a notice, excuse me, let me go back, is supposed to use the state of Texas, the Secretary of State is supposed to create a website where every owner has to register their project. So I've said in meetings, what if I'm installing a pool? Am I supposed to register because I'm installing a pool? What if I'm installing a deck? What if I'm adding a second story? What about all 5,000 houses that NewCo is going to build every year? But that's the way the draft statute says. Again, one deadline for everybody. So I say, look, my remodeling project is only 4 months long. I've got longer to file the lien than it was to do the entire remodeling project. How is that helpful for an owner? Well, the owner can go out and track down everybody and find out if they're still owed money. More important, right now we've got it's a fault-based system. If I'm an owner, I've opened the mail, it says I'm owed money, and I throw the letter away. Well, guess what? You just signed on potentially to have to pay that guy twice. But if an owner is diligent and opens the mail and says that, well, I better at least set aside enough money for this guy until we straighten this whole thing out, the owner doesn't have to pay twice. The current statute is unlimited liability. They can pay their general contractor 100%, and if that money doesn't get its way downstream, he might have to pay another 100%. Now that's a little bit of an exaggeration, but there's no limit on a liability downstream if that money never got past that first tier of payment. Again, the owner is burdened with tracking down the payment status every month. In addition, the statute had a lot of benefits provided to subcontractors that were not needed. I won't go into a whole lot of them, but it was stuff that, one reason that the legislature did not let this thing progress was because some of the Easter eggs that were in the statute. Now, it does have some advantages, I guess. There's no notices. You don't have to tell them about retainage. You don't have to tell them about a contractual retainage. You don't have to give them special fabricated materials notices. Some of these other language and requirements go away, so it's got the benefit of simplicity, but for owners and in the home building business, it's a mess. So I testified before the legislature multiple times and said, look, there's no cap on exposure. It becomes very unfair to Mr. and Ms. homeowner who may have to pay for example, the pool contractor once and then have to pay a second time to the gunite guy and the rebar guy and the electrician. In the interest of time, I'll jump through this, but we presented how this was difficult for title companies, for lenders, for owners, and at this point have succeeded in keeping it from progressing in the legislature, but it may still progress. Now, this is what we've proposed back to the legislature. Let's have just a simpler, a streamlined mechanics lien statute. Let's eliminate the notices. So let's not completely change the mechanics lien dynamic and paradigm. Let's just make it simpler. Let's make everybody a single type of claimant. Let's take 5 notices and drop them into 2, a past due notice and a retainage notice. Let's give them a simple state fill-in-the-blank form that's 3 lines. So we can make the mechanics lien statute simpler and but still protect owners, still protect home builders, still protect remodelers. So we can have a streamlined bill that everyone can read once and get without having to make unlimited liability and other problems. So where are we going to go from here? Either the folks that like the Senate bill are going to try and encourage people that opposed it, title companies, lenders, home builders, solve their concerns and get it passed. There's a discussion about do you make 1 and 2 family construction exempt from this and have them stick under the old bill? My favorite is streamline the current one, make it simpler, or we just continue on down the road with the clunky system that we've got now. It's a complicated world. Mechanics liens are difficult. Like I say, I've been doing this for a while. I'm actually manage the Texas chapter of the Lien Law Online. So you don't need to talk to me, but you do need to talk to some lawyer if you're going to have to deal with mechanics liens. Yes, sir. Yeah. Now, so if a lender is providing financing for remodeling or new construction, the bank will have a mechanics lien note with the homeowner. The bank will require the builder to give, and maybe subs to give, lien waivers. A waiver says, I'm relinquishing my right to file a lien. A lien release says, I'm releasing something I've already filed. But all of those would apply to the owner and the lender, because you're not giving it up just as a person, you're giving it up, or an individual or an entity, you're giving it up as to the real property. So you're kind of releasing the lien, your rights against the real property. But apart from that, I'm sure this was way too fast. I tend to do that, and hopefully this gives you a little bit of insight about what liens are and what they might become. Thanks.